Hey folks, welcome. Dave Brannen here. Are you in a situation where the insurance company is asking you to return to work before you're ready? Or are you being asked to do medical tests you're not comfortable with? These are some of the questions we're going to answer tonight on our live calls here. I've got some questions that have been sent in and some questions that I've taken from our disability forum. So I'm going to answer some of those. And I see people have been posting questions already in the chat. Please do that and we'll answer those as well. I'm David Brannen. I'm an employment and disability lawyer with Resolute. And let's dive into this thing. Please just post your questions as we go along, and we will start with Jason. Thanks, Jason, for participating here and for putting your question in. Let's see here. So Jason is asking, will I lose provincial disability if I showed medical improvement? For instance, I have panic disorder with agoraphobia. I always have trouble saying that. Okay, so let's dive into this. First of all, the rules for provincial disability do vary slightly from province to province. But for the purposes of answering this, it's not necessary that I know exactly what province you're in. A lot of these principles will be the same no matter where you're at. Now, it is definitely a massive source of anxiety, but improvement does not necessarily mean that you're going to be ineligible for benefits. The key thing to keep in mind with any of these provincial disability programs is their process is that they're looking for function, not necessarily just symptom improvement. So they don't just look at like whether your symptoms have improved and you're feeling better. They look at functionally, are you capable of doing work? So sometimes you can have improvements in symptoms and quality of life, but if you would be put back into a work situation, you would have immediate relapse. So the point is not just that you're improving, it's whether those improvements indicate that you would have the functional capacity to be able to carry out work. So it's very different, especially with agoraphobia, where that is an anxiety where people kind of isolate themselves in the house. It is very difficult to do social interactions, leave the house. If you're just getting better to the point where you're able to go to Tim Hortons or go for a walk or do these low-level type of things, that is not an indication that you're capable of working a 9-to-5 job at all. So to stay on benefits, like, for example, ODSP in Ontario, you must continue to have a substantial restriction. That is the test they use in Ontario in your activities of daily living. So if you approve enough where you don't meet that test anymore, then that is where you could get to the point where they cut off the benefits. But But again, it's not necessarily just that you're showing improvement. You'd have to show that you are capable of doing work. Doesn't have to necessarily be 9 to 5 work, but you have to be capable of doing some work that will be substantial. Okay. So the key thing here though, is I don't hide your progress. If you're improving, that's good for you. Be upfront with the provincial disability about it, and they're not typically looking to just pull the rug out from under you. They usually will give you a chance if you get to the point where you think you could return to work or try, they will usually work with you to make that happen. It's in their interest to support you, but it's unlikely that they're not going to be like a long-term disability insurance company that might just pull the rug right out from under you. All right. Let's see what else we got here. All right. This next one is a question I took from the forum. We could dig it up here. So this person wrote on the forum, my new LTD case manager clearly hasn't read my file. She's asking basic questions and wants frequent updates, even though I'm CPP disability approved. How do I handle this without aggravating her? Okay. So I think part of what may be going on here, and I had to condense this down. So this was a long post that someone did. Something else she had mentioned in there is that there was a lot of turnover of her LTD case managers. So the turnover is a real problem, and that does cause a lot of frustration. And once you have new people come in, I think this person asking all the basic questions, it is a new person, and the new people, they will ask a lot of information that they should be able to know just by looking at the file. But the that is something you will have to deal with, unfortunately. Um, that new person is probably trying to learn a bunch of files, and it's easier for them to ask a lot of these questions from you in the context of a phone call than to read through the file, because sometimes the file isn't always up to date or they can't find the new information. So they're trying to probably I'm just saying from their point of view, they're probably trying to do it in the most expeditious way possible, and that's probably what's going on. Now, um, one of the things you could do is put things in writing, and instead of doing the long phone calls, you could summarize things in an email. Um, summarizing where things were, giving an overview of your situation. That is something you could do, although I'm not really big on just volunteering all kinds of information. But if you know the kind of information the person's looking for, then that is something you could help out with. Um, I'm trying to think of what else I would recommend here. I guess the thing is, unfortunately, you just try to be cooperative with them, and hopefully that the frequency of the calls will go down. And then if you have a new case manager come along, you'll probably be back in the same boat again. Now, if there are any mistakes or anything, you can correct the record. They'll be fine with that if you find that this new case manager doesn't have everything correct. All right. This next one is interesting. I also found this. I was just digging around on the forum looking for interesting questions to answer. This one is an interesting one. So this one says, my insurer underpaid me for 3 years, forcing me into a consumer proposal. So that's similar to bankruptcy, but not quite bankruptcy. A consumer proposal is a step before bankruptcy when you make arrangements with creditors to make payments back without going into full bankruptcy. They finally paid the back pay, but my credit is ruined. Can I seek damages for the financial hardship they cause? Yeah, this is a very good question. Now, I'm not a bankruptcy specialist. I do know a lot of lawyers, particularly in the United States, who do a lot of bankruptcy law. It's not as common for lawyers to be involved in bankruptcy law in Canada for like consumers. It is quite common in the US, but not in Canada. Mostly lawyers are involved in bankruptcy in Canada are for companies and things like that. But in this situation, um, it's possible that they could owe damages for ruining your credit and causing problems. It's not like these are something that are called consequential damages, harm that happened because they broke the contract. So that is a loss that you can claim in theory. It's one of these legal theoretical losses, but it's one in practice that is very hard to get. The big hurdle in cases like this is proving that the lack of I forget how much they said. Did they say how much it was? They said he was underpaid. Oh, 200 a month. I think that was what they had mentioned. So you'd have to show that but for the $200 a month that they didn't pay you, you would not have gone into bankruptcy. Sometimes, like, even if you were getting the 200 a month, the overall money was not enough anyway, and you still would have been in the same boat. But maybe it would have made the difference. I don't know. You'd have to be able to show that loss of the 200 is what caused you to go into financial ruin, and that you wouldn't have gone into financial ruin anyways. Now, that seems like an obvious thing, but it is not easy to prove. These cases are always difficult because there will be a lot of scrutiny over all your spending. And so when you make a case like this, it's not uncommon for them to look at all your spending habits, and they'll look at things like, oh, are you doing cigarettes? Oh, what was this trip? Oh, what was that money for? So they'll start to question spending to show that really it wasn't just the lack of the money, it's that you was bad spending on other things. Now, I'm not saying that that's what's going on here, but that is the problem with cases like this, is it's difficult to show that the lack of the $200 a month is what caused it. Now, if you could show that, you may have a case to be able to prove that you have consequential damages. Now, the problem, even if you show that you have these consequential damages from the period of time, how do you quantify that in terms of money? That's another hard part. So your credit is ruined, but what is the financial loss? So in a court, you'd have to still prove what financial loss are you suffering because of the ruined credit. I guess you could look at how much your interest payments have gone up because your credit is lower. You've had to take out higher interest loans because of your credit. You'd have to quantify it in some way. And the way the law works is you'd have to show, if I didn't have my credit, first prove that your credit was damaged because of this, because of the lack of the $200 and not just in general. Let's just say you'll prove that. Well, then you got to prove what's the difference your financial situation now compared to if your credit was not ruined, and you have to calculate what that difference is. So these cases are very hard because it is extremely hard to prove the losses and the causation of the loss. But in theory, yes, you can claim this kind of thing. It's just very hard to prove it. And sometimes the expense of trying to prove it outweighs what you're owed. So it becomes impractical to go after payments in cases like this. Now, the other thing you might get in a case like this, if you can show that the lack of the $200 a month put you into financial stress, caused mental distress above and beyond what would be normal for someone in your situation, then maybe you might also be able to get aggravated damages or mental distress damages on top of everything else. Again, it's very unusual for someone to just bring a claim for this. It would be a very unusual case to bring because the money involved is usually not enough to warrant doing a lawsuit against the insurance company. But again, I think it's interesting, and there's theoretically a case there for sure. Okay, let's go on to the next one here. All right. This is a very common question. We probably get one of these questions a week on this topic, but we can never answer it enough because there are always slightly little different spin on it. This one talks about the insurer forcing a return to work based on an occupational therapy report. Doctor hasn't cleared me, but is kind of, they say, passive. So the doctor's really not really having strong opinions and will kind of go along with whatever the insurer is suggesting. Now, this person is saying, if I don't go back, I lose the benefits. So if they don't try the return to work that is recommended by the occupational therapist, their benefits would be cut off. Now, I always answer this question the same way, and that is that you should, in a situation like this, you almost always, especially with a passive doctor, you should almost always attempt the return to work because it is a very high-risk situation. Having an occupational therapy report that says a return to work is reasonable to try is something that you won't be able to overcome. Certainly, even if your own doctor disagreed, it would be very hard for your doctor to have more authority than an occupational therapist on this particular issue. So you are somewhat stuck in going through with what the occupational therapist recommended. And then if things change, because the occupational therapist won't know exactly how you'd respond and how things will go once you try this return to work. So if things change, once you start the return to work, you report to your doctor. If your symptoms get worse, if things go downhill, then it could be reasonable for you to stop the return to work. But the I do think that is something you can try. Now there are lawyers and others out there that'll say, look, an occupational therapist cannot clear someone to return to work. It has to come from a doctor. That is a real tough distinction to make. So I would be careful not to try to split hairs like that. Having an occupational therapist report saying you can return to work is going to be enough for most judges who would later look at this situation. And it would be impossible in most cases for you to justify not trying to return to work if there was an occupational therapy report that was a reasonable report, that it wasn't missing key information, like the OT knew the situation well, then you are pretty much stuck trying that return to work. Now you could, the one way you could do this is say, look, until my doctor clears me for return to work, I'm not going to do it. You could have, they're going to cut off your benefits if you do that. So it does put you in the an awkward situation where they cut off your benefits. Okay, well, we'll sue them. But again, like if now you're suing over not only am I disabled, you're also suing over, was it reasonable for me to refuse to try to return to work in this situation? Because a no on either of these questions will result in your benefits being not payable. So in other words, even if you technically were totally disabled from work, if not saying you could prove it, but let's just say that you were and you refused to do try the return to work, that'll still be a reason that they can stop benefits. And a judge would say, yeah, you've violated the policy. You have an obligation to try these return to works. The thing I'll leave with on this one is that it's very important with these return to work situations or any medical treatment that's being requested by the insurance company. It's very important that you look at your insurance policy, because some of these policies have very strict language about you must do it. So there's different wording that can be in there, but I would be cautious of just taking general advice from someone who has not looked at your insurance policy, because it could be very specific in there that you must try any of these such recommendations that the insurance company is asking. Sometimes it may be worded too strongly, but that is also a factor that's taken into account. How strongly worded is it that you must do these things? All right. If anyone has any questions, I'd love to take them. Just put them in the chat and I will answer them. In the meantime, we can move on. I've got a few others here that I've taken. This is another one from the forum. So this one is, I attended every session of the insurer's rehab program, but didn't improve enough to meet their targets. Okay, this is a very common situation. So this is the exact opposite. This is the person who did go to the rehab program. Now, this isn't necessarily a return to work, but this would be the rehab program. They cut me off for non-compliance. It feels like a trap. Is this legal? Now, this one is difficult because we don't know all the facts here. And this can be a classic insurer tactic. Like failing to recover during treatment is not non-compliance, but it all will depend on what is recorded in the records from this rehab program. Like, were you showing up on time? Were you doing everything that was asked? Or were you causing problems, not finishing, leaving early? Like, it all will depend on what's written in the records related to this. One person's non-compliance is another person's, I did everything. So ultimately it'll boil down to, like, what do the records say that were done? They will have kept records. Were you doing everything that was asked here? Non-compliance, it is different. Like, if you don't improve, that's one thing. But if you don't improve and you say, well, this is useless to do, so I'm just not going to show up, that would be non-compliance, right? So very important to get the facts here about what was actually going on. Um, like non-compliance would have to be something like refusing to show up, not trying everything. Um, Now, if you attended sessions and did everything they asked, but simply didn't get better, that would be proof that you actually are disabled. So, it would be important in this case to if this were me with this case, the first thing I would do would request all the records, the clinical records from that program to go through it with a fine tooth comb to see exactly what's written in there, and then review it with you to see if you agree. Okay, got another one here. This is a question I answered this one a while ago on the disability claim forum, but I thought I would bring it up again. Um, the case manager sent forms to my doctor for my transition to long-term disability. Should I review these forms with my doctor before they are sent? I think they mean before the doctor completes them and sends them into the insurer. I want to ensure they're accurate, but I don't want to seem difficult. So it's never difficult to want to be thorough with your disability forms. Very important. So that I don't think you're being difficult. In fact, it's best practice that you always review them with the doctor, though it's not always possible. I recommend when you're in this situation to book an appointment with the doctor just for the purpose of doing the form. That way, the whole purpose of the appointment is they can review the form with you, ask you some questions, and then even if you don't see the form filled out in its entirety, you can at least get a sense on what they're going to write. Um, Usually it's better if there is a form because at least the doctor has some structure about what's important and what they need to talk about. But doctors can focus a lot on diagnosis, whereas the important information is usually about function. So it's not so much that you have a diagnosis. What's important is how does that diagnosis impair your ability to do daily activities and work? So, writing down that you have depression is not enough. They need to say that the depression prevents you from working at a desk for 8 hours or 6 hours or something like that. But yeah, that is the best way to do this is book a specific appointment, go through it together with a doctor. They may not be able to fill the whole thing out while you're right there, but at least you'll have a better sense of what they're going to write. Okay, let's go to the next one here. So this comes up a fair amount. So this person just passed the change of definition. This is the point in the policy where it moves from any occupation, so from own occupation to any occupation. And this person is saying that they just passed the change of definition and the letter says benefits will be paid to age 65. Does this mean I'm safe forever? What should I expect now? Now, I'm going to go out on a limb and say I'd want to see this person's letter when they're saying it says benefits will be paid to age 65. It's usually not written quite that way, but that's how it can be interpreted by people. But who knows? Who knows how it was written? But generally, it does say that it usually will say that there's an ongoing need to prove ongoing proof of disability, and if you continue to prove disability, the benefits go to age 65. That's often what it says. No, you're never guaranteed to have benefits paid to age 65. Okay, you have to always prove ongoing disability. Now, usually the insurance company at a certain point, they might only check in with you once a year, once every 2 years or something like that. But there's no guarantees. So no, they will not guarantee to age 65. Age 65 is the maximum benefit age for most, like a lot of these group disability policies. But and insurers will move these into like what they call a maintenance mode. That's where the review drops from monthly reviews to usually annual reviews or sometimes even biannual, honestly. So, but you're still, in theory, you have to still prove disability. And if things change, you have an obligation to tell the insurer. So what would you expect in this situation? Basically getting a form once a year and filling it out and making sure you fill it out accurately. Okay. Let's look at this next question. So this one says, I'm on LTD from 2 jobs due to cancer. I want to return to my morning part-time job, but I'm too fatigued for my afternoon job. Will afternoon LTD benefits continue, or will this mess up my claim? Huh, this is an interesting one. Hmm. I think in a case like this, you'd have to be very clear with the insurer about attempting to return to work. Usually, like LTD is not going to cover 2 different jobs. So I'm guessing the LTD is covering the afternoon job, and this person is want to try to return to a different job they had. So it's yeah. So someone can be on LTD and work 2 jobs. It's rare, but the LTD is not going to cover you for both jobs. Usually, it's only going to cover one of the jobs. And so you'd have to be very careful about returning to work in one of your jobs because the insurer can use it as evidence that you should be able to do your other job. Okay, so it sounds like this is very rare because usually LTD will not cover part-time jobs. Usually, you have to be above like well, I guess the minimum is about 20 hours a week. So I guess you could work 20 hours a week one place and 20 hours a week somewhere else. But I would be very careful in this situation, honestly. Ultimately, though, it boils down to do you have the capacity to do the job, the afternoon job, I would say, if that's what's covering the LTD is attached to. Because LTD is attached to your employment. It's not attached to just jobs. Like it's your employment. And as long as you can prove you don't have the capacity to do the afternoon job, then the fact that you could do some of the morning job would not necessarily disentitle you from long-term disability benefits. And if you had that job at the time, like both of these were concurrent jobs, I also don't think that it would be an offset to earn that money against your LTD. But that is again something you'd have to argue with the insurer about. I wouldn't start this afternoon job until you really discuss it with your doctor and make sure that that you have a plan in place and also to clear it through the insurance company and put this through as some type of a rehabilitative employment. And when you approach it that way, it forces the insurer to view this as a work trial while protecting your benefits. If you go ahead with something like this without pre-approval, it just opens the door for the insurer to do whatever they want and to take the least charitable view of the whole situation. Okay. If you've got a question, don't feel free to put it in the chat. I'm going to keep going. I got a few left, but I might end this. I might do a little bit of a shorter stream tonight just because I'm a little tired out from a busy week already. But I'll stay as long as people have questions. But if there's no questions, we'll just call it an early night. I do have a couple left here. We'll just finish up. And then if no one else has any other questions, we'll just call it a night. And I'll see you back here next week. Let's look at the next one here. So this one says, I was approved for CPP disability. Will the insurance company deduct from my LTD payments? Okay, this is a very common question we get all the time. The answer to this is it depends on what your LTD policy says. Not all LTD policies deduct CPP disability, but most of them do. The overwhelming number do, but not all of them. It's good to keep that in mind, though, because I have in my many years of doing this, I do run across policies where CPP disability is not deducted. So it's very important to keep that in mind. But most often, yes, it will be deducted, and usually it's deducted dollar for dollar. So, for example, if your LTD payment is $3,000 and you get approved for $1,000 in CPP, then what would happen is you would start receiving $1,000 in CPP, and your LTD would be cut down to $2,000, so that your total benefits remain at $3,000. Okay, you don't get to go to $4,000. You get to get the $1,000 from the CPP, and your LTD now goes down to $2,000. This is not anything improper. This is how some of these policies are designed. And I do point out to people that your employer, whoever signed up for this long-term disability policy, it's normally the employer They chose to structure it that way. When insurance companies sell these policies to companies and businesses, they offer them a range of options. There is options that the employer can get where CPP disability will not be deducted, but those policies cost more because think about it. In this example I gave you, the person would be getting $1,000 more a month. So if the insurance company is going to pay $1,000 more a month on the benefit being approved, they're going to charge a higher premium. So these plans where CPP is not included, they just cost more. And so a lot of LTD insurers just don't do them for that reason. All right. Oh, we got a question here. There we go. A couple of questions from folks. Here's a good one. Isn't Canada... Okay, let me read this one. Can someone on Canada Life Ltd enroll in a 2-year college program if they remain under the care of an OSI clinic? Stated anywhere in the agreement. Okay, without losing their benefits, the person wanted to know. What is OSI? I gotta Google that. What is OSI? Operational stress injury? Is that what that is? OSI? That's probably what that is. Yeah, yeah, okay. That's what I thought. Operation. I was just looking it up here. Yeah. Well, it really depends. So yeah, RCMP and veterans. I will say that the LTD policies for RCMP and veterans are much more flexible when it comes to this kind of thing. And so my gut feeling would be they are more open to allowing people to do retraining while continuing to get benefits. So I have known, for example, I've known veterans who, well, it was veterans, but they were like a health professional veteran, but they were on the Sun Life plan. Now you're on a Canada Life plan, it mentions, but anyway, it doesn't really matter. They did pay for schooling and things like that and continued benefits. So if it's through the plan, I'm always thinking it's Sun Life for veterans, RCMP, but maybe it's switched to Canada Life. Anyway, it doesn't really matter. I think you have to talk to them about it because the plans for veterans in RCMP they're not like normal plans. They do have, there's a bigger focus on trying to enable retraining, and they're way more like normally I would tell you no, like you can't do college and stay on these programs. Now, CPP disability, they have their own requirements. You'd have to check in with them on what they would allow, but they also could allow it. With CPP disability, you'd have to check in through the vocational rehabilitation program for CPP disability. You just call them up and ask them about it, and they can connect you with a person in that program. And with LTD, you'd want to ask the same thing. But my gut feeling is that there's a lot of flexibility there for these plans for veterans and RCMP. Yep, you're welcome. Okay. Did I hit all the questions? I thought I had one more. Oh, I did have another question. Yes, I did. Let me see if I can find it. Somebody had emailed it in. Yeah, let me go and see if I can find it. Yeah. Just bear with me here, folks. I'm going to see if I can find it. Okay, where is it? And if anyone else has questions, just put them in the chat there. I'm just getting this. Just give me a second while this loads up. There it is. Okay, I got it now. Okay, this is the one that someone had sent. I'll put it in and pop it up here. They sent this in last week, I believe. So this one says, I'm a dual citizen living in Slovakia. I am officially disabled under Slovakian system. So that would be similar to probably provincial disability, maybe, or Canada pension disability, whatever their system is over there. But Canada doesn't recognize it. Does the Social Security Agreement help me qualify for CPPD? Ooh, okay. I do believe that Slovakia, and I don't know off the top of my head, but my gut tells me that they are part of the Social Security Agreement. Most countries, most European countries and Canada have a Social Security Agreement. So that if you've paid into the Canada pension plan, you can use credits toward the Slovakian plan and vice versa. Now, the agreements only help insofar as it gives credits. It doesn't help you qualify for the disability question itself. So you'd still have to prove that you meet the CPP disability criteria, which can be different, I guess, from the Slovakian criteria. Now, I would tell you that it's possible you just applied for Canada Pension Disability and got denied, like 90%, not 90%, like 60% of people the last time they did a study of that. So it could just be that you got denied and you might have been approved if you kept appealing it, maybe. But it's hard to say. It's hard to say. So in theory, like there are different tests for disability, and it's possible you got originally rejected in your CPP, but you might have been able to get approved if you gave more information, better medical records, that kind of thing. Now, depending on when you were denied, you have to appeal within 90 days in Canada. So you probably are past that, maybe. I don't know, but that is something you need to figure out. So just because you're approved in Slovakia does not mean that you can be approved in Canada. It's not evidence. You still have to go through the Canada CPP disability approval process. What I would suggest you could do is, what would I suggest you do? Well, you might have to start over a whole new application in Canada and apply. If you're getting the benefits, I don't know how it works though. If you're getting active benefits in Slovakia, I don't know if you can get active benefits from both countries. That is something I do not know off the top of my head. I do not know that, but I guess the only thing you could do is be to apply for Canada Pension again and go through the entire process right up to the tribunal and see if you get denied there, then it's game over. Now, maybe you already went to the tribunal and been denied. If that was the case, then you would not be able to keep appealing it unless there were some exceptions and things. So I don't know your exact situation, so I can't really give advice. Okay, here's another question. This one says, how dangerous are insurance adjusters and occupational therapists to disability claims? Very good question. So let's start with the insurance adjusters. So insurance adjusters are quite dangerous because they have the power to basically approve or deny any claim. A lot of frontline adjusters and insurance claims managers, in theory, they have the power to approve and deny, but in reality, like they have less authority than maybe they did like 20 years ago. So they have to follow a lot of policies and procedures. And it may be even a situation where they would personally approve the claim, but they're getting told from above that, no, this is a claim that can't be approved. Okay, so that can go on as well. But in terms of dangerous, I mean, they're dangerous in the sense that they have the power to deny the claim. And so this is why it is in your interest to get in his best, to be, in the best relationship with them as possible, and to give them whatever information they say they need. Now, occupational therapists, they can go both ways. Like, they can be dangerous. They can also be very helpful. Occupational therapists are dangerous to a claim because they can give opinions that go right to the heart of the matter. Occupational therapists focus on people's function, particularly in ability to function in a workplace with disability and with accommodations and all these things. So if an occupational therapist assesses and gives an opinion that you're capable of working with accommodations and these kinds of things, then it is very dangerous to your claim. Very hard to undermine those. Not impossible, definitely not impossible, but it does. Like, we will rely on an occupational therapy opinions to get cases approved, and I did that recently. It was the reason the case got approved, was the occupational therapy report. But we've also gone against them. We have to do our best to try to find where the occupational therapy might be flawed in their opinion, often by showing maybe they don't have all the information or they missed some important information. That is usually how you'd go about trying to undermine them. Okay. All right, folks, I'm going to leave it there for tonight. I need to take a little break. Had a long day. I'm not sure a lot of you guys can relate to that. So I'm going to take a little break, and then I will be back next Tuesday with some more topics and questions. I'd encourage you, if you, it'll be next week, same time. Just, you can email your questions in advance. You can send them to support@resolutelegal.ca. Support@resolutelegal.ca. Here, I'll just put it in the chat. Resolutely. There it is. So you can send your questions there, and then that helps me because I can prepare them in advance, and you can write out a longer thing. You don't have to try to type it all out while we're on the chat here. All right, take care. We'll see you next week. Thank you for attending.